going to very briefly explain all of the various civil lawsuits that Karen Read is a party to. This won't make sense yet, but it's about to. And yes, that includes the potential defamation lawsuit against Karen Read and Turtle Boy that the McCabe's, Alberts, and Brian Higgins have threatened. Karen, of course, was accused of the 2022 killing of her then boyfriend John O'Keefe by backing over him with her Lexus SUV during a blizzard after a night of heavy drinking. But Karen has long maintained that the police, as well as other people attending the party, conspired to frame her for this murder. And over this past summer, a jury found Karen not guilty of any crime to do with the killing of John O'Keefe. But throughout the trial, John O'Keefe's family has maintained that they believe Karen did it. And toward the end of Karen's criminal prosecution, the O'Keefe family filed a civil suit against her for wrongful death as well as infliction of emotional distress. And in their lawsuit, they also included 2 bars as defendants: Waterfall Bar and Grill and C.F. McCarthy's, where Karen Read had gone out drinking with John earlier that evening. The O'Keefe family is essentially alleging that the amount of alcohol that these bars served Karen contributed to John O'Keefe's death. Because Karen has been acquitted for all charges related to the death of John O'Keefe, she can no longer ever be found criminally culpable. That would be double jeopardy. But as was famously the case with O.J. Simpson, you can be found liable for somebody's death even if you're found not guilty criminally. And that is what the O'Keefe family are trying to do. They are trying to say that Karen is liable for John O'Keefe's death. Every single one of the claims in their civil suit relies on the assertion that Karen Read hit John O'Keefe with her vehicle. I personally believe that Karen Read is factually innocent of hitting John O'Keefe with her vehicle because his injuries do not in any way match being hit by a vehicle. There is no reasonable way to explain the lack of broken bones, the lack of lower body bruises or injuries at all whatsoever. There's no tire mark. I'm not going to go back through all of the reasons why it's ridiculous. About a month ago, during a hearing for this civil lawsuit, Karen's lawyers announced that they're going to add 10 cross-defendants. They said that they wanted to add cross-claims against Brian and Nicole Albert, Jen and Matt McCabe, Brian Higgins, as well as members of the Massachusetts State Police in their personal capacity: Brian Tully, Yuri Buchanan, disgraced, dishonorably discharged, disavowed ex-trooper Michael Proctor, and also the Massachusetts State Police and the Canton Police Department. But before Karen could file her civil suit, several of the people that she said she was going to sue announced that they were going to sue her. Did they announce it? Let me rephrase. They filed a legal brief, which media outlets reported as them announcing that they're going to file a defamation lawsuit. What's weird about this legal briefing is I couldn't find it on the docket, so I don't know. I'm not sure. I got this from Boston 25, so I am assuming they checked and made sure it was real, but grain of salt, I guess. Anyway, this is the non-party's opposition to Karen Read's motion to add parties to that lawsuit. And I have to show you something I think is funny right out the gate. In these kind of filings, when there's a large group of people that all have the same goal, they usually get a nickname in the document. So for example, in Karen Read's lawsuit, they refer to the McCabes, Alberts, and Higgins as the House defendants, because there's multiple defendants in this suit, and they are the defendants that were at the house. But in the McCabe, Albert, Higgins filing, they call themselves the Commonwealth witnesses. We 5 are representative of every witness in the Commonwealth. There were literally, I'm pretty sure there were 60, hold on. Okay, in the first trial, the Commonwealth had 66 witnesses. But yes, these 5 people surely represent every single one of those. Defendant Read's proposed cross-claims and related factual allegations against the McCabes, the Alberts, and Mr. Higgins are a vile work of fiction lacking any basis in fact, evidence, or law. I mean, we'll see about that. They say that Karen Read wrongfully maligned the Commonwealth witnesses to evade responsibility for her actions on the morning of January 29th, 2022, and for causing the death of Officer John O'Keefe. Y'all see the psychological element here to calling themselves the Commonwealth witnesses and making it sound like Karen Read maligned all 66 people that testify. They say their defense will include motions to dismiss, potential removal of these claims to federal court, as well as counterclaims against defendant Read and third-party Aidan Carney, also known as Turtle Boy. Great, cool. Those don't exist yet, though, so you have to actually file them for this to mean anything. They say they should not be forced to litigate these false allegations and their own defamation claims in the pending lawsuit brought by the family of Officer O'Keefe. Awaiting trial individually and in conjunction with third-party Aidan Carney, embarked on a strategy to defame the McCabes, the Alberts, and Mr. Higgins by falsely accusing them of inter alia murdering and or covering up the murder of Officer. Inter alia means among other things. Defendant Read did so to evade responsibility for causing the death of Officer O'Keefe by diverting attention from herself. I'm not sure if there's any exceptions to this, but my understanding is that things that you claim in a legal filing are protected from defamation. So sometimes legal filings will have claims like these that can't be considered for the purposes of defamation lawsuits. But not only does it protect the McCabe's, Alberts, and Higgins from making these wild claims, it also protects Karen Read from claims that she's made in lawsuits or that her lawyers have made on her behalf. So I'm really confused what defamatory statements they're going to accuse Karen of making. I also thought this was interesting and deeply evil. They say defendant Read did not testify on her behalf at her trial, and they bring it up twice. They're like, oh, and also in 2025, she was retried, and she again did not take the stand in her defense. And maybe at face value, I wouldn't find this offensive, but let me show you some context. These folks have made a whole website called Defending the Truth. This is presented as some kind of general fundraising foundation thing that they're going to get into. Remember how they talked about Karen invoking the Fifth? This is from that donation page. We did everything the justice system asks of witnesses. Not one of us ever invoked the Fifth Amendment because we have nothing to hide. It's very confusing on if their plan for any money they raise is to use it for their own legal defense or to use it for this fund that helps future witnesses. They're also no longer witnesses, so okay. Anywho, so they say that they're going to sue Karen Read and Turtle Boy for conspiring. It's honestly ridiculous in my opinion because they did try at one point to get witness intimidation charges brought against Karen Read and also I think more brought against Turtle Boy. Anyway, a grand jury declined to indict Karen Read for conspiring with Turtle Boy to intimidate witnesses. It is extremely easy to get a grand jury to indict someone. There is a famous line that says you can get a grand jury to indict a ham sandwich. I believe that at this point, Karen Read's counsel has asked for all of this to be consolidated for the purposes of depositions. If there's going to be multiple lawsuits and the same exact people have to be deposed about the exact same subjects in all of those lawsuits, it is just such a waste of everybody's time and everybody's money to have them come in on different days and have lawyers ask them essentially the same questions. So I believe that at least probably will be agreed to. But what the House defendants, aka Commonwealth witnesses, are arguing is that they would like to remove possibly some of this to federal court. Some of the claims in Karen's lawsuit are under Section 1983, which is a federal statute. Karen's team has brought this in state court with all of the rest of their claims, but my understanding is that the defendants do have a chance to ask for it to be moved to federal court if they have like a good reason. I'm not a lawyer, and I certainly don't understand civil law. It's crazy. Every time I try to understand tort law, I'm like, what? Anyway, one of the counts in the lawsuit that includes the Alberts, McCabe's, and Higgins is under a federal statute, so they might ask for it to be removed to federal court. There are no cameras in federal court, and I can't imagine these people ever want to go through a televised trial again. Hopefully this answered some of the questions that people have. That is everything I know about this. If you are a legal professional and I got something wrong, please correct me. Love you guys. Drink water. Bye!